Okay, the live stream link is up.
Ready then?
And currently we have 4 board members. A 5th is coming on board.
Yeah, Ms. Sport's coming on board.
Exactly. And I think hospital.
Ms. Sport, we can hear you. You're being live streamed.
Okay. No, thank you.
You're welcome.
Okay. Sorry. I don't think you heard anything much.
No, you're just fine.
Okay.
Alan, how many board members do we have that you can see there now?
Dr. Valentine's coming on board. That'd be 6. There comes Dr. Weather is coming aboard.
Right. Okay, Alan, I'm going to go ahead and start and call the February meeting of the Board of Medical Examiners.
Oh, feedback, Dr. Collada.
Yeah, I'm hearing him.
That's from your laptop.
One second. We got a couple here. Try it again.
Working fine.
Can you
That's
hear me
good.
now better?
Yes,
Alan?
sir. That's better. Yep.
Okay, great, thank you. We're going to call the February meeting of the Board of Medical Examiners to session then. And
Dr. Johnson, I'm sorry to interrupt. Could you speak up a little bit? It's difficult to hear you.
Okay. I'll call the meeting to order, the public session of the February meeting of the Board of Medical Examiners. If you would, Vincent, go ahead and call the roll.
Okay, we still have some feedback.
Yeah, it's Dr. Horton's mic.
Who's Mike?
Dr. Horton's laptop was the,
Okay. Need to turn off your mics. Okay. Both of your laptops have your mics on.
Yeah, I'm not hearing it. I'm hearing it.
Okay, but
there we go. That's got it.
okay, so is it working now? We still having any feedback?
No, you're good to go now.
Good enough. Thank you very much. All right, great.
Vincent, if you call the roll.
All right. Dr. Weather,
Here.
Dr. Johnson,
Here.
Dr. Horton,
Here.
Dr. Batson. Dr. Batson. Dr. Thomas. Dr. Thomas. Ms. Sport,
Here.
Dr. O'Neill. Here. Dr. Clark,
Here.
Dr. Valentine,
Here.
Dr. Taylor. Dr. Taylor. President, you have a quorum of 7. You have 3 not present at this time.
Dr. Taylor, and who else?
Dr. Taylor, Dr. Thomas, and Dr. Batson are not with us at this time.
Okay, thank you. As is our custom, if we would just take a moment to remember those that have been lost during the pandemic. Thank you very much. Dr. Collada, would you read the public declaration now for us?
The meeting is being live streamed on YouTube with a 15 to 20-second delay, and the meeting is being recorded as approved by the board. We invite any public comments to be sent to us at publiccomment@lsbme.la.gov. That's publiccomment@lsbme.la.gov. Remind all of our staff and board members that your mics will be muted and to please use the raise your hands function to be recognized. And I ask that once you're recognized, please state your name before speaking. I also advise that if you mute your mic yourself, you may be unable for the staff to turn it back on for you. We continue to require that all referrals to from public session to executive session be made before executive session starts. And they will be handled in executive session if approved by the proper majority of the voters.
Thank you very much. We have, next is approval of the minutes. We have actually 2 sets of minutes that we need to approve. We have a December the 30th emergency meeting that there was a change or 2 in that I think you have a chance to look at there. I think, Christy, you had one of the changes there, or is that now satisfactory with you, Dr. Valentine? So that we can have a motion to accept them at this point?
I'm trying to get into it. Could maybe Mary go over what it was that was changed?
Sure. So originally, I had come into the meeting, it must have been just a minute late or so, and I had not heard that Dr. Valentine motioned to approve the resolution, which she did at the very beginning of the meeting. And so that correction was made with Dr. Taylor having seconded it.
Okay, then if that's what's reflected, that's exactly what I requested. Thank you so much, Mary, for going back and checking that.
Absolutely. I apologize that that had to be done.
So we now have a motion by Dr. Valentine. Can I have a second?
Sports
Well,
second.
4 seconds. All in favor, say aye.
Aye.
Any opposed? Then the minutes of the December 30th emergency meeting now stand as amended, Vincent. All right. Now we'll take up the approval for the minutes of January the 24th. Everybody have a chance to take a look at those. I think Ms. Rita has a question.
And I just might be confused about this because it appears to me that on page 11 on the video screen, item 17, Dr. Johnson and I were recused. And the footnote says down at the bottom, it's on item 04.00.01. He and I were recused. And the footnote says we were, but the grid showing the votes on that item in the public session listed both of us as yay votes.
Apologize for that. We'll get that corrected.
Thank you.
I do have
Dr. Horton.
one correction also noted on page 7, the very beginning, under board staff present. it still lists
Leslie Rye.
Leslie Rye, and she's
Right.
no longer with the agency.
Sorry about that one.
No problem.
Thank you very much.
Mhm.
Else, Dr. Horton. Anything else noted from any of the board members? Dr. Creswell, anything else?
No, sir.
Okay, then I'll accept a motion to accept, to approve the minutes as amended by
Moved.
Dr. Horton and Dr. Creswell.
So
Mary,
moved.
you have those corrections?
Yes, sir.
Okay, can I have a motion?
So moved.
Dr. Horton moves. Can I have a second?
Second,
Sports
Second.
second.
Dr. Valentine, seconded.
Dr. Valentine seconds. Or was that Dr. Second Valentine? Well, it's not that, that's not funny. Okay. All in favor? Say
Aye.
aye. Any opposed? Then these minutes stand as corrected. Moving on now to the next item, which is follow-up items. Dr. Collada, I think you and I really appreciate Ms. Wilton working with me and Dr. Collada on this particular issue of language and applications for licensure and whatnot, and trying to get as much information on there as we could. So I'll let Ms. Wilton speak to this at this point.
Good morning, everybody. What we were trying to do is merge the concerns of everyone for ensuring that every licensee had fair notice of the fact that they would be held to knowledge and compliance of the rules and law, but not make an onerous requirement for us spoon feeding them the rules and law by making them sit through mandatory courses year after year, and for CLE or otherwise. So we had talked about a notice that was clear, unequivocal, couldn't be disregarded, and essentially anyone who could read the English language and was competent to sign this document, which we're assuming every licensee would be on notice that they were held to these requirements. And by submitting the application, they acknowledged that and they understood that. At the same time, we are providing the rules available to them, the rules in the law. It's available to them if they want to look at them on their own. We make it convenient for them. They don't have to go anywhere other than our website. In addition, we are providing CLE courses that are voluntary, CME courses on a voluntary basis that will allow them to earn CME credits for taking the course. And our assumption is that some of the institutions will make that mandatory of their own accord, even though we don't make it mandatory because it's right there for them. But in any event, we thought that this satisfied, on the one hand, the due process issues that Ms. White had raised, and then on the other hand, the ability of, if you'll pardon the expression, grown-ups to be responsible for themselves. And so we think that language accomplishes that purpose.
Thank
Dr.
you so
Creswell
much,
has his hand raised.
I really appreciate your work on this along with Dr. Collada. And it seems to me that this is a moderate way of looking at this to protect the citizenry, in that the licensees would surely be aware of what the rules are. And also it would be less onerous on the licensees to have the rules printed in a number of places and also, I believe it, yeah, Vincent, was it a 2-hour course of CME that would be available to
An
them?
optional 2 hours.
Anybody could take that at any time, and we're gonna put that together. Now, I think there was somebody had their hand raised. Who is that?
Dr. Creswell.
Oh, Dr. Creswell, I'm sorry. Dr.
All right, good
Creswell.
morning. Good morning, thank you. I was not made aware of this change at all, because it completely kind of is against what the concept of the rules course was. The reason why I proposed this rules course specifically was because I wanted to make it mandatory for the licensees to take a course that they can attest to, then stating that they have gone through each of the rules. We will update them and notice them on a routine and regular basis. And my understanding was that the only issue was the timing and frequency with which these licensees would be taking this course. But when we then have physicians that we are reviewing or investigating, someone could not then state, I did not know. By making this available but not mandatory, that I did not know is still there. We can have someone attest to saying that, you know, that they acknowledge that this is there, and I understand making adults responsible for being adults, but the literal plan was to make this very similar to other state agencies that have medical jurisprudence courses as a requirement for licensure, and kind of conforming to what the other states do as well, and mandating that these physicians take these classes. I was not aware that any change had been made.
Dr. Valentine has her hand raised, and so does Susie Allen.
Dr. Valentine? Dr. Valentine?
Yes, I'm here. I was just trying to get off mute. I think that ignorance of the law is never an excuse. So there are many laws that we don't know specifically the ins and outs of. We try to, you know, do the right thing, make good decisions. But if we were to say, oh, I didn't know that was the law, that doesn't make us, you know, not responsible for those actions. So I think that, you know, physicians have a lot of things that are mandatory. Our licensees have a lot of things that are mandatory, a lot of things that they are going through and dealing with right now. And if this is an opportunity for them to, I mean, if they attest to it and choose not to read it or whatever, that's their decision ultimately. And hopefully they continue to make good decisions and do the right thing and take care of Louisianians. But I don't know that we need to, you know, add to mandatory requirements on people with advanced degrees.
Thank you
Dr.
very
Taylor
much.
and
Ms.
Dr.
Wilson,
Kipsworth.
would you please read what we had crafted? And that might, I'm not sure, but it might be helpful to Dr. Creswell as to what you had said that will be on all the licensure documents now in reference to this matter.
Yes, I can. Let me get to it really quickly. Let me get to it.
Trying to satisfy as many people's concerns as we possibly can.
While we're waiting, I want to let you know that Dr. Taylor, Kim Sport, and Susie Allen all have their hands raised.
Okay, let's see. All right, this is what we said was that this notice would be placed at the top of any application and also right before the final submission part. And it would be in a prominent color, size, and font. It would say, read carefully and take notice. This application and any subsequently issued license, permit, certificate, or other authority to practice in the state of Louisiana are subject to all Louisiana laws and administrative rules governing the practice of medicine and allied health. A copy of the laws and rules can be found on the LSBME website. All applicants are hereby placed on notice that they are responsible for knowing the laws and rules and for complying with them. By submitting this application, you expressly acknowledge and agree that you are responsible for knowing and complying with the laws and administrative rules governing the practice of, and then here we'll put whatever application, whatever occupation they're applying for. And then down at the bottom, before the final submission area in a prominent color, size, and font, the language will state, by submitting this application, I expressly acknowledge that I understand and agree I am responsible for knowing and complying with the laws and administrative rules governing the practice of license category, a copy of which are available for my review on the LSBME website. Those will be at the top and bottom of every application. Again, we're trying to satisfy the due process requirement here. Due process being nobody can claim they were surprised that it was required that they know the law. Not that you didn't tell me what the law was, but that I didn't know I was supposed to know it. That solves this problem. And so from the due process aspect, that solves this problem. Whether anybody else believes that we should do more than that, and we think we have to make them take a course that we put out there, that's a policy decision. That's not my decision. But this was to address the, gosh, I didn't know I was supposed to know the law and the rules. This solves that. So that's the language.
Patricia, I believe also that Mrs. White was also part of this as well, and so that we did allay the worries that we had as far as due process went, which is what we were indeed trying to do here.
That's correct.
That's where we are at this point with the product that myself and Ms. White and Ms. Wilton, Mary and Dr. Collada came up with as a solution to this. Now, we also have, who else do we have now? I think Dr. Taylor, maybe, is he?
Dr. Taylor, Kim Sport, and Susie Allen.
Okay, let's go with Taylor first. Jim?
Thank you, Dr. Johnson. Yeah, can you hear me?
Yes.
I have two questions. The first question is, according to the plan that's proposed, would first-time applicants still be required to take the course, or would this choice to take or not take a course starts from first license at time 0? And my second question is, if we're going to refer that says all these laws are available on the website, are we then going to put an exhaustive, comprehensive list on the website so that in the case that someone says, well, I went to the website and looked at this, and this, and that law wasn't on there, does that obligate us to put a completely comprehensive listing of every law on the website so that we can say, we told you to look there, and if you look there, it should have been there? So first question is, first time licensees, are they still going to be required to take the coursework, or is it going to be an option? And secondly, to what degree do we need to put every rule on the website in order to make sure that we do our part on this instruction? Thank
Okay,
you.
well, let me hop in real quick just on the second one. The first one is policy, and I leave that to the members. But on the second one, we already have all of the laws and rules on the website, so we're good there. But the first one's policy, so I leave that to the members.
I'll take the
So
first one.
it is a
open.
complete listing of everything in Title 37.
Yes, sir.
All right. Thank you.
Okay, on your first question, Dr. Taylor, that is a subject for discussion today as we get on through this. As it stands now, is a requirement for the first licensure. If it's the wisdom of the board that that's not necessary, that's fine, but that is going to be, we do need to discuss that. All right, let's go to Ms. Sport next.
Thank you, Dr. Johnson. I was a little surprised when I read this because I also thought that we might be doing something more from a CME standpoint. And I think that maybe we could consider at least adding a sentence in this notice that you're encouraged, something encouraging a CME course on all of the rules and laws that apply to physicians. They don't have to do it, but at least they'll be encouraged to do it. And it might be an easier way
One of
than.
the boxes, Kim, that, and the verbiage that Ms. Wilton has put together have a statement in there as well that you're certainly encouraged to take a course. Okay, let's do Susie, then we have Dr. Kalata. Susie?
Yes, thank you. Just to add on, first of all, point of clarification, this course is a 3-hour course. But to add on what, in terms of Dr. Taylor's and Ms. Sport's questions, I would also like to suggest that we, in that message, put a link to the actual course once it's up on our new CE Broker format, because we have precedent for this in terms of our supervising physician course, where we revised the course and then put it on CE Broker. And I did send out an email to all of our physician licensees saying, since 2015, we have required people to take this course when they are getting an SP credential. We strongly recommend that you take it as well if you are supervising PAs. And so some of them have. So I would say we could have, similar verbiage in this regard, where many of you may have taken a similar course years ago. We strongly recommend that you refamiliarize with yourself with the rules and laws as they have changed, or words to that effect. But also I wanted to clarify that, as most of you know, we do, and Dr. Taylor referred to this, there has been a rule in the books for a long time that upon your first renewal, you have to attend an orientation that then morphed to an online rules course that was more extensive in some ways than the previous physical, in place orientation. So physician licensees have been taking an already existing rules and laws course online since 2016. What we've been doing lately is just revising it to be more inclusive of additional rules and also some federal legislation that gets some of our licensees in trouble sometimes. Thank you.
Thank you very much for that, your comments. I think that I'm going to let Dr. Kalata comment just in a minute as well on the link that I believe is part of this that you recommended, Susie, and also the hours. My understanding it was 3 hours, but I think there's been some more discussion on that between 2 and 3 hours. So we'll vote on that as well. And so that everybody does understand what Susie and Dr. Taylor, and there has been a requirement for your first recertification to take a course. That has been mandated. There's a lot of discussion about mandates, wisdom of them for postdoctoral students as to what the wisdom of that is. That's not, as Ms. Wilton said, that's not her call. That's up to the wisdom of the board, which y'all think our licensees should be mandated to do by us, which is whatever it is. So let's see, is anybody, I think Vincent, your comments, please.
Yes, sir. Operationally, what we had planned to do is upon completion of the renewal, they will get an automatic email that will have a PDF of the law and rules for that category of license and a link to the course. And we can tell them there that this is an optional course that if you'd like to take it, you can get X number of hours of CME depending upon your determination. It will be free and it will be counted towards your 20 hours requirement of the agency. So all of that was going to be explained in a separate email that would go after the process of renewal or initial application is finalized. So again, I think that that's what we had planned to do to address other people's concerns. All you all need to do to help us is to say, A, how many hours, and do you want to continue with the mandatory course for the first renewal or leave it just like it is for everybody else? We'll make it happen.
In other words, not the renewal folks, at first renewal, your recommendation, or the question is whether or not to make that mandatory or not.
It's your decision to.
You're gonna have a link,
Yes.
as Susie suggested, to make it even easier for them, and you're gonna have the course, and Vincent, you thought 2 hours was enough rather than 3, or do you feel strongly about that one way or the other?
I have no feelings, whatever you want it to be. You know, when it was 3 hours and mandatory, we thought that that would be a way to say, okay, if it's mandatory, I get 3 full hours. Again, the course can be taken in less than 3 hours. It's up to you all to tell us what you want to certify these people for in terms of CME. And it's really up to you.
Okay, so just quickly then, I'm gonna try to summarize what we have here. It's a very good discussion. I appreciate everybody's interest in this. Very important. Ms. Ford would like to, and Susie, I believe as well, for our consideration, Ms. Welton, to add to that an assertion in the boxes that you have, recommending or strongly recommending that the licensees avail themselves of the opportunity to take the test. Can
Yes.
you give us a rendition of that quickly, so maybe we could
Absolutely.
agree to that now, Kim?
Certainly.
Okay, cool.
Let me do that really quickly here while you're speaking.
Okay. And then the other thing we will need to vote on is whether the course should be 2 or 3 hours. And then of most importance, whether we have any mandates for any licensee to take this other than this box and this strong recommendation.
Dr.
There may
Johnson,
be some of us that would like to have, yes.
could we add the proposed consideration of the length of the course to the agenda specifically?
We just have the discussion of the language for the applications.
Right.
It would be in the language of the applications as to how much I guess they would get for a thing. I don't know. We can do that later, I suppose, if it needs
You
to
can
be
add it to the
added to
agenda right
next.
now. Yeah, let's vote and be done. It's done.
Well, let's just let Patricia finish this, and then when we get around to what we can vote on, we'll see what, Mary, you think we should do from a legal perspective. Larry, Dr. Cresswell, does this addition help you with your worries with this?
I'm perfectly okay with whatever the board desires. I completely understand 100% from the due process standpoint, and you guys do solve the due process issue. That really wasn't my concern, because I understand from a due process standpoint, we can easily do it this way. It was just something that I desired to expand upon, as Dr. Allen stated, the mandatory course. I was just making it more comprehensive with all of the new rules. And the desire was to have this course taken before the first licensure and not before the first renewal. But whatever the board desires is.
We'll bring
I'm
that
okay
up
with.
in the discussion, and you can speak to that as your thoughts on what's best for the citizenry.
Sure. No problem.
Susie has her hand raised.
Ms. Wilton, do you have it yet?
Yes,
Completed.
it would say this application and any subsequently issued license, permit, certificate, or other authority to practice in the state of Louisiana are subject to all Louisiana laws and administrative rules governing the practice of medicine and allied health. An online course is provided on the LSBME website here. There would be a link at no cost to the licensee. This course is provided, this course will provide X number of hours of continuing medical education credit. All applicants are strongly urged to take this course.
Just quickly before I get to Susie, Ms. Sport, does that verbiage capture your sentiments?
Yes, it does.
Very good. Susie.
Yeah, just a couple of things. One is that if we're going to use this new format in CE Broker, at this point, you do have to already have your license. But also, I just wanted to say, as somebody who's taught grad students for years, if you make learning something option, it's a very rare bird indeed who's going to take optional. It's a very rare bird indeed who's going to do it. And this mechanism not only makes you sit down and read it, but it also quizzes you a bit to make sure you understand how to apply these rules in, real life scenarios. So, again, it's up to the pleasure of the board, and I understand.
Knowledge of the law as to the relevance of your licensure is a different one. It just comes down to the philosophy here as to how much we should hold somebody responsible to a mandate. But goodness, let's see, Dr. Valentine.
Yes, I'm thinking about this and to suggest to the medical schools that they incorporate this in some fashion in the curriculum for maybe the fourth years before they're leaving, just telling them about Louisiana. And of course, they may decide to go other states, but it would also signal to them the importance of learning the laws, whichever state they go to. I mean, this is a practice that they're going to have to continue regardless of the field and regardless of the state. So I didn't know if it would be something that maybe we should talk to the medical schools about having as part of the curriculum before graduation.
I think that's a great idea, Dr. Valentine, and we can certainly bring that up. There's all sorts of new courses and whatnot to prepare for the practice of medicine, ethics, and everything else. Susie, I'm interested in what you were talking about as far as the nuances, the new rules, how they're incorporated and whatnot with Vincent and Ms. Wilson. I'd like to be assured that any change in the rules from year to year is updated on the link and all. Are we capable? We're doing that as we should.
And just so everybody understands, we wait until the state has finalized the language of either law or rules before it's finally posted. So usually that's done around September, October, no later than November, depending upon when the state finalizes all that line.
Thank you very much.
And in terms
Mary,
of
excuse me?
I beg your pardon. In terms of the course, though, one of the things which came up at the last meeting was that any rules course we have for physicians should also have a section at the end, which I've been working on, that basically says, and just to draw your attention to the most recent changes, here they are. I mean, the rules, the rules course will reflect the most recent rules, but there will also be sort of a summary, what have you, section at the end, which will say, these are the ones which have, changed most recently. And again, we also do that in the quarterly newsletters, and the rules are changed on the website, as people have pointed out.
With an excessive font and color and whatever else that you just to try, that's so important to try to get the new changes in place, because that's what we all need to know about. So I really appreciate y'all all working on that. I hate to belabor this, but let me ask Mary now. Mary, we need to try to come to consensus on a couple of things here, including the number of hours for the course. is that, do we need any motions to be able to take that up? Or
Yes, so-
add that to the agenda? How would you propose we do that?
Yes, so I think this conversation regarding the notice of language for applications has really morphed a bit into a more extensive, and thus far, we're just touched on the number of hours and whether to make the course mandatory. And so at this time, I'd like for, if we could give a motion to add that to the agenda and then have a more fulsome discussion regarding those particular 2 points prior to any vote and hear from any public comment that we might have regarding that.
Very good. That's great. Thank you so much, Mary. If I could have a motion to add those 2 items. Dr. Taylor. Dr. Taylor.
You're muted, Dr. Taylor.
So moved.
Okay, Dr. Taylor moves both of those. Dr. Horton seconds the motion. All in favor to add these to the agenda, say aye.
Aye.
Any opposed? Nay. Okay, so we will now let's just do the simplest one first. I think any discussion as to whether or not this is a 2 or 3 hour course. Vincent, Susie, do you feel strongly it should be a 3-hour course since you've done so much work on it?
Yes, sir, I absolutely do. And I'll tell you partly why. Currently, we have the SP course up there for 2 hours, and that is only a subsection of what is dealt with in the physician rules course. So I think it totally should be 3 hours. Obviously, some people, physicians are highly educated and read quickly, but it's really the quizzes and things that take the time because you don't always get them correct and you have to go back or whatever, or think about it again. So, and part of our new system that we're using on CE Broker, you sort of have to do that a little bit more than before. We're working on changing this, but anyway, I definitely feel that 3 hours, would be appropriate given the number of hours that we're doing for a smaller course.
Very good. Relevant to the other course. Mary?
Yeah, I just wanted to clarify, because I wasn't sure. This particular course that we're talking about, Susie, that you just mentioned should go from 2 to 3 hours. Is that a course only for physicians on the law and rules, or is that a course for everybody on the law and rules?
The course that I'm talking about is a physician rules course. Now, we do have courses for CLPs, PAs, we have separate courses. And also, all of these courses have a discussion of what the board is, sort of what the board is and how the board works and what the complaints process is. But then they have, they're each different in terms of the rules and laws pertaining to the different specialties. So we are speaking only about the physicians on this one.
Okay, thank you.
Thank you very much. Okay, Alan, would you please check and see if there are any comments from the public on our discussion so far?
Okay, no public comments so far.
Okay, then we can have a motion now for the course on the rules available to our licensees physicians to be 3 hours for 3 CME hours of credit and free. Can I have a motion? Dr. Horton, so moved. Can I have a second?
Taylor, second.
Dr. Taylor seconds. All in
Taylor.
favor?
Aye.
Aye.
Any opposed? Any opposed? Then it's all, then that's passed. You have a 3-hour course. Now we need to discuss, I'll open for the discussion of what, if any, mandatory, is there any need for a mandatory, or excuse me, a mandate for physicians either in their first licensure, their first at the end of a year, or at any other time? Is there a mandate for taking the 3-hour course? Any discussion? Let's see, Dr. Clark.
Thank you, Dr. Johnson. Just a question for information. It sounds that listening that we already require our new applicants to take a course and an orientation. Would this be in addition to that course? I guess Susie was kind of mentioned that we already have that in place. So is there a need to have the initial applicant take another course on top of the orientation course? That's my question.
No, this is the same course, sir. In other words, currently, and it's not initial for physicians, it's not the initial applicant, it's upon first renewal. But many of our other licensee groups actually take it as a prerequisite for licensure. But for physicians, it's first renewal, and it has been in place. And when I originally put this online, you know, at the request of Dr. Merrier, then you know, physicians were already attending a 3-hour board orientation. This course had some, you know, has some quizzes in it. So you actually have to show that you're paying attention, if you get my drift, you know, and you have to indicate that you've processed, you know, the information. But this is the same thing. This is the board orientation essentially as required by our rules, but physicians take it upon first renewal.
Dr. Taylor?
Yes, I think that we should absolutely continue to have first-time licensees be required to take this. I've spent we're in a public session, right? Let me be careful how I say this. I've spent almost a year in academic medicine. And I'll tell you what Susan says is absolutely true. Not necessarily from a judgment standpoint, but just an observation standpoint. If you give them the option of least resistance, they're going to take it every time. And that does not serve the public safety. Our primary goal here is not, unfortunately, to make things easier for every physician. Our primary goal here is to make sure that they are adequately equipped to take care of the public in a safe manner. That being said, I think that we should require it first time up. I think you should have to take it every 3 years at a minimum because the law changes quickly. If I didn't look, the only reason I know about the laws is there's a staff attorney that's paid to tell me every month what the laws are. Okay. So, and I realize I'm privileged with that. So first time up is my recommendation, and every 3 years on a renewal. And I think that matches, we always look at best practices. And best practices are what I would assume that other states are doing or moving towards in their jurisprudence. I think New York, Texas, those states are moving in that direction. And I don't think there's any reason why we shouldn't be following that lead. Thank you.
Barry?
I've just wanted to let you know, if we do change that, we'll need to do somewhat of a rule change to accommodate that for physicians licensed under the normal law, so to speak. And then we'll probably also have to do a rule change for the IMLC. I'll have to take a look at that one. That one will always have to take place following licensure due to the structure of the IMLC law.
Dr. Thomas? Dr. Thomas? Dr. Terry Thomas?
You're on
You
mute.
want to help her with her mute or whatever?
Yeah, she might be double muted, which was what I had to deal
On
with.
her end, yeah. It's not on our end, though.
I had hoped that we could have a good discussion of this today, and I think we have. It's not an easy decision. It has a lot of ramifications in every direction. All the points are well taken and excellent. I'm not sure, Mary, that despite the work that we've done this time, that some of the points that are brought up, including the potential need for a rule change, do you think it would be worthwhile to table this for a month and let's work on this a little more? In particular, the year, which years there would be mandatory to take the rules course, the original, the first renewal, and then this is a, Dr. Taylor, this was not a motion, I don't think, this was discussion as to whether or not we need to have this mandatory every third year. I guess we could vote on that and then have something else come up. I don't want to in any way circumvent the discussion of this, however. Very important. What's the wishes of the board? Do you think are we ready to vote on that? Or if someone would make a formal motion, we can.
We have 3 hands raised.
I have Colette
Patricia.
White.
Yep.
Yes.
Ms. White.
Yes, this is Colette. Can you all hear me okay?
Yes, we can. Thank you.
Thank you. I'd just like to make 2 points because I think we are kind of straying away a little bit from, only in part, from my original concern. We have addressed the due process issue, and that is to let physicians know, to make them aware that there have been changes to the rules and that they need to do their due diligence, perform their due diligence to make themselves familiar with and aware of those changes. But I don't want us to forget, or let me say this. I just want to remind everyone that the ultimate mission of the board is to protect the public by making sure that our physicians and healthcare providers are competent and knowledgeable. And so I think we do this through that licensing process and also through the educational component. So with respect to those physicians who find themselves before the board for having violated rules and laws that they were not aware of, these are typically things that were changes, additions, updates, changes in the laws since the time that they originally took their course. So I particularly would like to see some emphasis on making them aware of the changes in the law and having some mechanism to ensure that not only are they aware of them, but they have done what's necessary to become familiar with them. Thank you.
Thank you very much, Ms. White. Once again, Dr. Thomas.
Yes, can you hear me now?
I can, thank you.
Thank you. So what I was saying was in regards to what Dr. Taylor's comment was, I would assume I don't. And so I would assume the vast majority of other physicians don't have a staff attorney to alert them to when new laws come into effect. Is there anything that we can do, and I don't expect an answer right at this moment, but is there anything that we can do to make this less onerous? I feel like, today there's so many hurdles that physicians have to overcome in terms of like CME and all of these things. Is there anything that we can do to make this process less onerous for our licensees?
Thank you very much. I'll let Ms. Wilton start the discussion on that answer.
I think that was in part what we were trying to do with this notice. It was trying to merge the consideration. Again, we're the rules do in some part, guide medical practice. Of course they do, but by and large, it's not the actual practice of medical treatment. It's not how do you operate on somebody. It's not how do you perform a medical test on somebody. It's what does the law say about who you can collaborate with and how do you do it? I mean, I don't mean to be too reductive about it, but this is laws and jurisprudence about the way that we license these occupations. And so as Colette referred to, the way this originated was she kept hearing that our licensees came to the table saying, gosh, I didn't know that was against the law. And those of us on the other side of the table kind of rolled our eyes a little bit saying, come on, you know, you wouldn't tell that to the police officer who said you ran the stop sign. Of course, you know, that's against the law, but to the extent you're going to claim that, we have a couple of ways of addressing that. One, we can literally make you with a gun to your head, sit down and take this course, this interactive course where you have to keystroke in answers to the quiz. And then we have proved that you actually interacted with the course. Doesn't mean you understood it, doesn't mean you retained it, doesn't mean you didn't pay a secretary to sit there and do it for you. But we have documentation that somebody entered those keystrokes on your computer and now we hold you to it. Or we can put a notice on your application that says, by golly, I'm a professional. I want a license from you. And I understand that if I ask for a license for you, I know that I have to follow the law and the rules. I know that you've provided a way for me to see the law and the rules right here, handy dandy. All I have to do is click on this link. And oh, by the way, if I take your course, I get CME credit, which you also require of me. You're giving it to me free. And I understand and I know that I can't now come to you and say, I didn't know that was a rule or that was a law. So this all originated from due process, and that's what we tried to solve. I raised my...
And you added in there, please take the
yes.
Please take the course
yes.
on the volition of Ms. Ford.
Right. So that's the way we tried to make it.
This down to, let me interject something here. We need to just interject something. It seems like we have two strains of thought here. And I don't want to put any words in anybody's mouth, but Dr. Taylor's philosophy is that we should indeed mandate this for our licensees on their first, on their recertification, and as it already is. It's not adding anything. That's what we do. And then at every third year to mandate that for them to have to take the test and somehow prove that to us, which will require some rule changes or additions or whatever, as opposed to Ms. Ford, who says with the wording and the boxes and that we have now, plus the addition that to actually plead with them in a very nice way to take the test. I mean, to take the course and the test to even increase their chances of understanding the rules. So we have those two. I think those are the two things that we have in front of us. I'd be willing to accept a motion and try to get a further elucidation of the feelings of the board voters after Dr. Valentine's hand.
Can I just make one more quick point, Dr. Johnson?
Yes,
just give one more, 30 more seconds. If we want to do something more rigorous, policy decision, not my call. If you choose to do something more rigorous, this notice language isn't really going to help you. We really just kind of need to scrap the idea of the notice language and just have it rule-based, because every application and every different renewal in each different year is going to be different. So you can't use uniform language. So I just throw that out there for your consideration. If you choose to have these different renewal, requirements every third year or such and such have you, that I'm totally fine with that. You can kick it over to Mary in the rules section and have that all delineated in the rules. And you really wouldn't need this kind of language at that point.
Dr. Val, thank you very much, ma'am.
Yes, sir.
Dr. Valentine.
I was just gonna support your suggestion to table this for a month, maybe flush it out a little bit more and make that motion. I like the language and the work that Attorney Wilton and team put together, but I think that we have some really good points that were raised. So if we want to flush it out a little bit more for a month, and bring it back, that's my motion.
So we have a motion. Do I have a second to table this for shall we say, thought?
Second, Thomas.
Dr. Thomas, all in favor?
Aye.
Aye.
Any opposed to further thinking? Okay, thank y'all for this discussion. Very important. Very important, and we'll see how we do. We'll bring it back with this caveat. Mary, we need to know what that means on this third year mandate. If we add that to it, what that really means as far as these rule changes and whatnot, because that could get into, not, I don't know if it'd be changes, additions or what, but you said there's gonna be some sort of rule manipulation that will be required. We need to know really what that means.
Okay.
We'll talk about that. I'm going to move on now to hospital duty to report, which in this particular issue, it's apparent that we're going to need our counselors, legal team to visit with us on some of the ramifications of this issue. So what I would like to have is a motion to carry this into executive session, which we will do a little later. If I could have a motion on
Thomas, so moved.
Dr. Thomas.
Ford seconds.
And second, Dr. Ms. Ford. So all in favor of putting.
Dr. Taylor has his hand raised. I don't know if this has anything to.
No, it's just a second.
Second.
Okay.
Okay, all in favor?
Aye.
Any opposed? Thank you. That'll be in the executive session. All right, Vincent, on the average number of days between submission and approval.
All right, we are trying to put together for you all a dashboard, and there is an awful lot of information. And so what we're trying to sort it out is finding the outliers and the reality of the work that we do. If you remember, we function as 15 different licensing agencies with 15 numbers, 15 different people. And we want you to look at this information, and if you're comfortable with it, this is all the information you want. We will put it in an easily presentable place and wait for you to see it on a regular basis. It's also going to help us in terms of improving our quality internally. But we want to look at the most important thing is there's a time that we have no control over from the time of the initial application till the time that the information is complete. Now, that may be it may be delayed because of fingerprints. It may be delayed because of the failure of the applicant to provide us documentation. Our rules clearly state the burden is on the applicant to provide the information to us. Once all of that is substantially complete and pre-approved, then we have a burden that we've set arbitrarily inside our agency that from the time the licensing analysts and supervisors have said this application is complete, we give ourselves 10 working days to approve that and grant the license. Now, in between the first time from the application to the completion, there may be issues relative to, oh, there was a yes answer and this had to be investigated and that delayed it. There was an issue relative to the fingerprints being rejected and they had to do them over again. All of those things apply, but a lot of that is beyond our control. We do clearly have a lot of control in the 10 days afterwards, but we want you to see those issues relative to what we have no control over, so that when you are queried, you will know what's going on in the agency in terms of the 15 different license classes. So that's why I'm asking if you're comfortable with this data, we'll design what it looks like for you after we know what data we got to put in.
Does that also cover the next item,
Yes,
submission and
both of those.
pre-approval, both
Right.
of those?
Both of those.
Just to bring everybody up, this has been something that's been ongoing since I've been on the board, actually, and a number of things that we're just trying to get a little better hold on the amount of time it takes for a license to be completed. and it's multifactorial, the problems that would slow it down. Some by the licensee, maybe some by us. Vincent, is anything that we've done, or we should do, or we could do to make our process internally here any better? Is there anything else we need as far as just the quality and the quantity situation, quantity of time needed?
Again, I think we're doing the very best we can do, but I think this will point out areas where we may be able to look to improve.
Okay, this is just some data to look at performance improvement.
Right.
Basically.
Performance improvement.
Any questions for Dr. Collada on this? If not, we'll move on to communication information and antitrust update. Vincent.
Okay.
Next is communication and information.
All right, with regard to the antitrust issue, I'd like to let Ms. Wilton tell you what's been going on. This is regard to the protections for the antitrust for the board members in terms of decisions that we make that could be viewed as antitrust and the actions we took in the legislature. So I'll turn this over to Ms. Wilton.
Okay, so I'm so happy to report that the final step in the undertaking of the review program with the Attorney General's office was achieved last week. Because the Joint Legislative Committee on the Budget approved the Attorney General's request for the additional attorney position to staff the program. The processes and procedures have already been set up, so that program will be up and running as soon as the final interagency documents are signed and the monetary transfer is made. And so it seemed to me like this was a good time for a quick update on the status of antitrust law and anti-competition issues relating to occupational licensing boards. And I gave you a real short memo to you indicating that antitrust and anti-competition continues to be a focus in the current regulatory climate. At the federal level, the president issued a very broad executive order in July of last year that called for federal agencies to address numerous issues, including unfair competition, using the various methods at their disposal, including adopting pro-competitive regulations and rescinding regulations that create unnecessary barriers to entry that inhibit competition. And also at the federal level, last April, the United States Supreme Court denied the Louisiana Real Estate Appraisers Board's petition for review on the question of whether a denial of state action immunity in an antitrust action against a board or board members should be immediately appealable or can only be appealed at the end of the case after the board or members have incurred all the costs of litigation. And this was really particularly disappointing because the court had accepted a similar case once before, seeming to indicate that it realized that the question was an important one to answer, but that case got settled before it got to the court. So we were all really surprised that the court didn't take the cert petition in our case, in the Louisiana case. The FSMB was instrumental also in filing an amicus brief in that case. 23 states joined the brief. It was just very disheartening. Two pieces of proposed federal legislation have also failed to gain any traction. In the 2017-2018 session of Congress, a bill was filed that would have prohibited awarding damages against boards or board members for antitrust so long as certain underlying conditions governing their actions were met. That bill bounced around 4 committees, then died. In 2020, the delightfully named Occupational Licensing Board Antitrust Damages Relief Act only made it to 1 committee before it stalled and went no further. So federal legislation doesn't appear to be forthcoming. Interestingly, when I did a 50-state search for either new laws or new cases involving antitrust issues, there were very few results. As far as new laws are concerned, it seems that most states must have either believed their existing statutory schemes were sufficient, notwithstanding North Carolina dental, or they responded quickly with any statutory changes, so there isn't anything recent. I found only 2 cases where state courts analyzed an anti-competition argument in a licensing board context. I'll just run through them pretty quickly but they were interesting, and they can give some just see how other states are handling it. In Colorado Real Estate Commission versus Vizzy, a 2019 Colorado Court of Appeals case, The Colorado Real Estate Commission wanted to discipline a licensed real estate broker for a violation of his statutory duties under Colorado law. The case went to an ALJ who determined that the broker was in violation and imposed a financial sanction, but did not impose a public censure, which the Colorado board had requested. That's the same thing as our public reprimand. The board accepted the ALJ's findings and sanctions, but in its final agency order, it also went ahead and imposed the public censure. The broker appealed to the Colorado Appellate Court on various grounds, including that the action against him violated antitrust law based on North Carolina Dental, but the court disagreed. The court said that unlike whether teeth whitening was within the scope of the North Carolina Dental Board's authority, here enforcement of the statutes at issue for real estate brokers was squarely within the authority of the Colorado Real Estate Board, so it clearly was an action by a sovereign state entity. The court then looked at the issue of improper motive and found that there was no evidence in the record that the Colorado Board's action was motivated by anti-competitive animus. And at the bottom, essentially, the court just distinguished this case from North Carolina Dental and said it didn't apply. For anyone who might be interested, the broker also appealed the fact that the board imposed the public censure, even though the ALJ had not done so. The broker said that this exceeded the board's authority, but the court disagreed and just based that on the fact that the penalty was not manifestly excessive in relation to the conduct being sanctioned, and therefore it was not arbitrary or capricious or beyond the board's authority. The broker tried to appeal to the Colorado Supreme Court, but that court denied the writ. Just this past December, in matter of oncology and hematology specialist DBA OHS Pharmacy to operate a pharmacy in New Jersey, the Superior Court of New Jersey reviewed a final agency decision of the New Jersey Pharmacy Board denying a medical group's application to operate a pharmacy within a medical practice. The Pharmacy Board denied the application based on a New Jersey law that prohibits physicians from referring patients to healthcare services owned by them. There is an exception in that law that says it doesn't apply to medical treatment or procedures that are provided at the practitioner's office, but the board said the exception didn't apply because pharmacists do not provide medical treatment. The medical practice appealed on various grounds, one of which was that the denial was anti-competitive and violated antitrust law. The doctors said that the board was just trying to prohibit non-pharmacists from competing against them in the free market. The court disagreed and said that there was no evidence that there was any attempt to provide an anti-competitive motive, and the practice was just asking the court to infer that, and there was no evidence that this would hinder competition among pharmacists in any way. So the bottom line is that apparently boards are either gun shy and are restraining themselves in the actions that they're taking for fear of being sued, which is not a good thing, or they're being extremely cautious and making sure that they're running their decisions by the appropriate authorities to ensure that they are not running afoul of antitrust laws. And in fact, in this medical pharmacy case, they had gone through an elaborate screening process with their state review to ensure that it wasn't anti-competitive, and the court actually noted that in its decision. One of the things that the FSMB noted in its recent 2021 annual report was that occupational licensing boards need to be mindful of anti-competitive barriers, not only in discipline, the discipline context, but also in the licensing context. And there was an interesting discussion in several of the forums at the recent FSMB regulatory seminar about testing, and even so far as to say some of the form documents that boards have as to whether that is accessible across the board to every aspect of society and every aspect of cultural demographics, inclusive on all levels. to ensure that there are no barriers, not only to practicing the profession, but also entry into the profession as well. So that's my little update. Happy to answer any questions offline or provide additional information or do any additional research for anybody that would want it. But I thought it was a good time to do it since we're moving into a new era with our own review of our regulations to shore up and firm up our chances of being covered by state action immunity through the AG program. Thanks.
Thank you so much for that very hard work and that very informative report. I think just in summing that up, it's not lost upon us, Ms. Wilson, that literally every moment of American life at this moment, it has something to do with antitrust potentiality. And we cannot be too careful. Everything from licensure to just everything to do with the business climate in America. And to protect the board, we need to avail ourselves of all the expertise in the state of Louisiana and even beyond in any decision we make that you think has anything to do with the antitrust world. So we'll move. Thank you very much for that. Any questions that you have, Ms. Wilton, if you would perhaps individually ask her or query her offline would be great. This is just Byzantium to the max as far as the rules and regs. Vincent, you want to visit with us for a moment about this marijuana situation?
Yeah, so we received a request about doctors who are being treated with medical marijuana and how should they be allowed to practice. We got some information from Dr. Cresswell, and we drafted what we think is a response that's reasonable and addresses everybody's concerns at the agency. But I look to ask you all, not only to approve this letter, but since this letter was not going to be necessarily public, it might be a worthwhile thing to either turn it into a statement of position or an advisory opinion that the board puts on its website so that people understand that no matter how benign we think marijuana is, it is a category 2 narcotic in Louisiana, and they are responsible for acting as if they were being treated with a category 2 drug, whether it's Percodan or marijuana.
Okay, so in other words, it would be a potentially mind-altering drug that you, like anything else, if you were treated for something for pain, if a physician was, he should adjust his practice that day or during that interim of taking medication to protect his judgment vis-a-vis his patient.
Yes, sir.
Is that so? So Vincent, this is just in that category now. What would be any change or any need for anything on that?
I think the reason is there's such a belief in the common parlance that marijuana is not harmful, it's nothing to worry about, it's safe to use, everybody's going to be fine if they take it. And maybe we need to clarify the fact that we got the question tells you that indicates that some people are not clear what marijuana really is.
So what would you and the legal staff have us do as a board to help you with that question?
A, approve this letter, and B, let us turn the language of this letter into an advisory opinion that we publish on our website.
Dr. Thomas?
Yes, just a quick question. So whenever we are adjudicating cases, if a physician, let's say, had been if a physician had some sort of substance abuse issue, like with alcohol, and then they turned in, or a physician or any licensee turned in the appropriate monitoring sample and was found to be positive for marijuana, or do we even test for that?
Well, again, what they test for is the determination of the treatment center that the doctor might be in. This really is not at that level of after discipline and monitoring. This is so that the doctor who has chronic back pain gets prescribed marijuana should know that he shouldn't be doing complex surgery while actively under the influence of that drug for which he's being treated with his chronic pain. I think that this is the key here, that this particular request was addressed to, and it calls to the fact that there's a common parlance that marijuana is not harmful, it's okay, we shouldn't worry about it. But just like any category 2 drug, it has the potential to alter the way that we integrate, think, and perhaps even function at a fine motor level. And I think this is why we have to be concerned about what our physicians who use this or any category 2 drug might be under.
So your letter and your advisor is that marijuana is a category 2 drug vis-a-vis number 1, just its classification, and therefore, Vincent, it should be your practice of medicine, if you're in any way taking it, should be adjusted to that.
Yes.
And that's it.
That's all we want to do.
Okay, and the reason is because it's marijuana, and it's just a little bit of an unusual world that we live in vis-a-vis marijuana right now.
Yes, sir.
But you have no choice until it's no longer this level of drug.
That's correct.
Okay, so can I have a motion then on the?
I'm sorry, I have one more question.
Okay.
Do we have, and certainly, I agree wholeheartedly. I don't think that anyone should be practicing medicine under the influence of any drug, especially when we don't know what the effects of that are. So I guess my question is, do we have any data on mental function, on decision-making capacity with the use of medical marijuana?
Well, the difficulty that we have, Dr. Thomas, is that we were beginning to gather that data in the early stages of the Louisiana medical marijuana law, when we had a near pharmaceutical grade, highly reproducible product. We now have gone away from that to this smoke raw product concept. And with this raw product concept, we have prescribers that are adjusting the subspecies of the cannabis sativa, where one subspecies is better for gastrointestinal problems and another is better for migraine headaches. And so there really is no consistency. I think the only consistency we can draw is that it is based in Louisiana law as a class 2 controlled and dangerous substance. And just like any controlled and dangerous substance in a category 2, we should be expecting the doctor to adjust his practice appropriately, or her practice appropriately.
So I don't know what the appropriate venue is for this, but this is the problem that I had whenever we were in charge of the whole medical marijuana thing. And that is that there's such a paucity of information that it's hard to do any kind of, good data-driven decision-making on this topic. How can we as an agency promote or ask for more research to be done on this topic to help us in situations like this?
Well, again, I think that's going to be very difficult to do. I think LSU was considering it. We have our adverse database up and ready to be running soon, and all of the things that we've done. But again, this is not about the science. This is about, we have a substance that by Louisiana law is a category 2 controlled and dangerous substance. And the question is this safe for doctors to use in practice medicine? And I think it should be like any other category 2 controlled and dangerous substance. It depends upon time, under influence, and what they're trying to do. So again, I'm not sure that I would want my neurosurgeon taking their.
Vincent, it comes down to the point, if you don't have this, then it's saying that you can smoke marijuana or do whatever you want to with marijuana, and perhaps be okay. We have no way of knowing that.
Right,
There'll never be any data to know that.
that's correct.
So, I mean, I don't know, if,
I'm
where
not trying to
we
make it
are.
data driven. This is based around the law.
Well, I'm not even sure that because it is, why do we discriminate against any other drug by, you just doing this because it's marijuana and it's, a question was asked? What about
Yes.
if anybody asked about Percodan?
We would say the same thing. It's a category 2 drug. And that's what I'm saying. I want to turn this into we have rules and we have rules that address the use of medications by mind-altering medications by physicians, okay?
Yeah.
All I want to do is make sure that the public knows we consider marijuana to be addressed just like those rules.
Okay.
We have
Clark,
Dr. Cresswell, Dr.
Thursday.
Clark.
Well, I think you swerved into my question, Dr. Johnson and Dr. Collada. I think we already have established rules.
Yeah.
I don't know, maybe we could get our attorneys to kind of see, read those to us. But this is no different than any other scheduled drug. And I don't think we need to treat it any differently. I think the point that Dr. Collada is making is we have to identify it as such. And I think that's fair, but I think we have rules in place. We surely can't have impaired physicians practicing medicine. And so, that's just the point I wanted to make. But I just like to know what our current rules say. Thank you.
That's what our discussion came down to last night, Vincent and I. Really, it's more of a notice than anything else. There's not any change in the way we would treat this level of drug with usage of a physician. Dr. Thomas again.
So respectfully, whenever we were doing our initial interviews about this topic, we had several experts that came before us and said that there is a dose-dependent difference between the administration of medical marijuana and then marijuana that is used for the mood, mind-altering effects. So, cancer patients receive, medical marijuana for pain, and that's certainly different from marijuana that's being used for intoxication or other purposes. I just want to make sure that we're making that distinction. And again, if there's more research that needs to be done in that area to clarify, because when the experts came before us, they said that there is a complete difference between medical marijuana and then marijuana that's used for social or intoxicating purposes.
With all due respect, Dr. Thomas, that might have been before they changed the rules to allow raw product. Now there really is no difference.
Dr. Cresswell.
I just wanted to state that I agree with Dr. Collada, Dr. Clark wholeheartedly. This is essentially the exact same as any physician who is being treated with a benzodiazepine for anxiety disorder, or any physician that is on MAT, medically assisted therapy, if they were on Suboxone or methadone. We would treat this the exact same. The physician has to know and be aware that if they believe they cannot practice medicine with reasonable skill and safety while taking this medication, they are to remove themselves from practice and to let the board know. Otherwise, they have to consume this, take the medication under the advice of their providing physician in a safe manner. And this is just letting them know we would treat it the exact same as any other Schedule II. And just to answer your question about dose dependent, I mean, I would say it's very similar to a physician who is taking 1 milligram of Klonopin versus 2 milligrams versus 3, or the frequency with which their doctor is prescribing. The duty of the physician is the same.
Dr. Thomas again.
I just want to make my position clear. I'm not disagreeing with anything that Dr. Collada or Dr. Clark or Dr. Johnson are saying. I'm simply asking that we make certain that we are making decisions that are data driven. Like, what data do we have to see to what no one has answered my question. What data do we have to show what the difference is between medical marijuana and marijuana that's used for social purposes. That's the only question that I'm asking. I'm not disagreeing with anyone. I'm just asking a question.
I think your question is valid, Terry, and what we'll do is we'll table this discussion until next month. Vincent, if you and the legal staff would look into any more data that's available on the dosage of an individual human being taking the marijuana that's available for them for medicinal purposes in Louisiana can be in any way, as far as the data quantified as to the safety of treating patients using that. And if you will come back with whatever information y'all can come up with, in particular in the state of Louisiana, but nationwide as well, best practices on this, and then we'll discuss that again, and then we will decide about your letter at that point. Thank you very
Dr.
much.
Johnson, we do have a couple of hands raised. Dr. O'Neill and Michael Francis.
Wait a minute. I want to do something fun for a second, if you don't mind. And that's this. Vincent,
Okay.
would you please introduce our new friend and welcome to the fray, Dr. Francis. Before I recognize you with a hand up, we're going to recognize you, period. Vincent, and also Dr. Creswell, will y'all introduce our new
I take great pleasure in introducing to you all Dr. Michael Francis. And Dr. Francis has a long history of working in the area of anesthesia and pain modification. He's joining us as the Assistant Director of Investigations devoted to our agency. And he will be working in that department. He goes to work officially the first pay period in March. So at this time, he's not all onboarded, but we brought him along to meet everybody at the public session. Let him see what goes on. So hopefully he won't reconsider before he gets signed on.
I'm worried that he may be resigning. But Dr. Creswell, would you please welcome Dr. Francis as well to your division?
Yes, absolutely. I would like to very much welcome Dr. Francis to the Department of Investigations. After a very long and exhaustive search, we felt that Dr. Francis was the absolute best candidate, and I'm very happy that he agreed to work with us. And as Dr. Collada stated, he has extensive experience in anesthesiology and pain management, and will be a tremendous asset to us and the agency. And I would like to welcome him and introduce him to all of our board members and the board.
Thank you, Larry. Well, then I will just formally introduce and welcome him for all the board. Thank you so much for this charge on for us. And with that, your hand is raised, sir. So we will recognize you, Dr. Francis.
Can you hear me?
Yes, we can.
Perfect. I guess according to Dr. Thompson's question concerning data-driven analysis, I would look at that in terms of how we look at opioids. The CDC has just changed or modified, I should say, modified their recommendations on how opioids are being prescribed because of what some consider a knee-jerk reaction. The current recommendations, which was in 2016, was to restrict daily morphine mill equivalents of opioids, whether it would be oxycodone, morphine, hydrocodone, or whatever, to 90 morphine mill equivalents a day. That is now being changed because you understand the whole, I guess, if we look at data-driven is not necessarily a sliding scale, but they did not take into account that people who develop opioid hypersensitivity or do they develop a certain tolerance to it, their requirements. And so a lot of times 90 mill equivalents, morphine mill equivalents per day did not adequately treat people who were in real chronic pain. And I practiced chronic pain for a long time in anesthesiology. I was in academics for 25 years. And it's a very, very difficult decision because pain is not objective, it is subjective. So it's a very difficult decision, and I'm pretty glad that I think my health grades are -2 now, but I'm not happy about that. But anyway, I think that there are a lot of things that we don't know about medicine, and we have to constantly use the data that we have on hand, and also use experience in terms of what reactions and decisions that we make concerning class 2, because still federally, marijuana is still listed as a class 1. But I just wanted to make a little comment. I also want to say I'm very, very happy and very, very excited about joining this very elite group of physicians and advisors and educators. And I know that I've got a lot to learn. I think that that's what I'm also excited about this time of my life, that I have a lot more things to learn, and I'm very excited about doing that and doing whatever I can to help.
Well, thank you so much for those comments and the comments on the data-driven situation with opioids and all that. One of the reasons that we're so happy to have you is your background and expertise in anesthesiology and pain management, that sort of thing. Because of course, as you will notice, as you go forward with this particular work, a lot of what we do are at least tangentially associated with that sort of problem, which is of course epidemic in our world that we live in.
Between I guess between April 2020 and 2021, 100,000 lives were lost to opioid overdoses, and that's mainly attributed to fentanyl. Also of incidents, the Supreme Court is taking up 2 physicians on the breadth and standards of practice of prescribing opioids. There's a physician in Alabama and there's a physician in Wyoming that starting March 1st, the Supreme Court is going to taking up the case of whether it is now criminal behavior for misprescribing opioids, just some out of information. So that's all I have to say today.
Well, we look forward to your comments in the future. Your expertise will be welcomed. Dr. O'Neill has a comment, I believe.
Can you guys hear me? Yes. Okay, good. This actually goes along with Dr. Francis just said. The reason, Terry, the reason there's no data is marijuana is a federal category 1 drug like LSD, psilocybin, and heroin, and a lot of other things. The federal government does not allow research in category 1 drugs without jumping through all kinds of hoops. So there actually has not been good research on marijuana since the 1960s or 50s, when it was initially placed in category 1, which was a decision the federal government made that long ago. To my knowledge, the only data that's solid when it comes to marijuana and capability of functioning has to do with the recent stuff that came out about intoxication with marijuana being just as disabling when it comes to driving as alcohol levels above 0.8. So just the reason why there's a dearth of research is because the federal government didn't allow it, and also there was actually, you guys might not know this, but the national lab to grow marijuana for any research that's done is actually in Mississippi. And actually Bob Heath back in the old days did studies looking at marijuana at Tulane in the 1960s. And I can talk to you offline if you want to know anything about that. Anyway, I just want to give you a reason why. I mean, it's not that people haven't been trying to pay attention to it. And I'll stop there.
Thank you so much, Dr. O'Neill. That you perfectly answered my question. Is there any chance that we could add some of the information that Dr. O'Neill said whenever we do this?
Sure. I think that what I meant was, let's take this month and you and your staff, Vincent, research this, and including anybody on the board that has any expertise like Dr. O'Neill, Dr. Francis, for data or reasons there are no data, so that we can answer some of the questions that all of us have, and in particular, Dr. Thomas and allay any apprehension we may have about the letter or any sort of standards that we do on this. Nobody wants any doctors to go around stone treating patients, but we need to have all the information we can have prior to making any sort of vote on your letter. Is that fair to you?
Whatever you want, sir.
Okay, that's what we want. So I'm going to go on to the president's report now, just quickly, a couple of things that are ongoing. Is Mariah on today? Do you know?
I know she's not on call. You want me to-
Alan, do we have her as a
She was not,
available to us?
she was
Do you
not,
know?
no, she was not included on the invite list.
Okay, fine. She as just a member of the public. Of course, she's a representative of the State Medical Society, is working on with us on the behavioral health issues of our licensees that may be under investigation and whatnot. We do have some more information on that this morning. I believe she may have a report for us at the March meeting. Vincent, is that correct?
They are finalizing the contractor to do the work. They're going to give final approval, we think, at the March Board of Governors meeting of the LSMS. And if so, we would like them to let us know, and we'll let the same contractor present to us what they're going to be doing at the March meeting of our board at the end of March.
Oh, that's just great news. We can't thank them enough for helping us with this, Vincent. Would you be sure to portray that? I told her that this morning, and we can't thank them too much. The other ongoing issue that I have is the ongoing evaluation of security in our area of Camp Street and in the building and whatnot that we had last month. Vincent, I believe that you have ordered some increased lighting, which was one of the recommendations. Would you tell us about that?
We're getting bids for increased lighting at this point in time. We're waiting for the electrical company contractor to come back with the bids, and based upon that, we'll submit those bids for approval, depending upon get the lowest, best light for the lowest price.
Remind us of where those, I recall there were some specific areas for lighting that you were taking bid on.
Along the side street, the Capitol, in the front of the building, exterior of the building, and also in the area of the alleyway between the two buildings.
Right, I thought I recall that. So that's great news. And we would hope that we would have a follow-up on recommendations next month on this issue as well.
We'll instruct Ms. Wilton, and I will get together with that person and have a follow-up report.
All right. I think he had told us this was a little earlier this month, but he would try to have it, as I recall. Okay, that's all I have in the president's report. What about your report, Dr. Collada?
Well, as you know, Dr. Johnson, you and I met with the Board of Nursing to see if they wanted to talk about rule changes, and they want no rule changes at this time. They continue to push for full practice authority. Despite repeated attempts, we've been having trouble scheduling a meeting with the PA Advisory Committee, but I think we finally got that settled. And we will be talking to them about what legislative agendas they want or rule changes that they might address. We're finalizing the electronic payment for license applications and renewal, and this will include electronic checks and credit card payment fees for both. And we're also initiating electronic check payments to our vendors and contractors. Continue to attend the Governor's Drug Policy Board. They meet and they are formulating recommendations for recreational marijuana to use to advise the governor. The Workplace Violence Task Force continues to meet. They're formulating various recommendations that include education, notice posting, institutional reporting, and other possible actions to protect all our healthcare workers. The Polysomnographic Advisory Committee is that they're recommending some rule changes, and we're working with them to prepare the proposed rules. The Athletic Trainings Committee met and wanted to have some rule changes. However, they are proposing legislation that would sweepingly change their scope of practice. And what we have been shown is that they want to have a situation where they work for a physician and the physician certifies what they can do, much like the PAs. We talked about some unintended consequences and explained to them what they are asking for may be too broad. They no longer want to treat athletes, they want to treat patients of any type. We talked to them about the definitions in the law. We learned subsequent to my completion of this report that This is being driven out of their national association, and they want Louisiana to be a pilot state of setting up a pattern of law changes. We don't know where this is going at this time. I'll continue to watch it closely and work with them. And we are going to be, if they want to keep if they attain the law changes that they want, it would require sweeping rule changes anyway. And we're going to work with them to make sure they get the rules that they want the best way we can in line with the law. We met with the OT Advisory Committee and their new leadership, and we're overhauling their rules, and the process is moving along steadily. We continue to work with Ms. Sport and LDH regarding the new breast cancer pamphlet. The contract is presently in the hands of LDH, and we are working together to revise the language of that pamphlet. We're beginning the process of redesigning the website. If any of you have any suggestions to improve the website, please email me your suggestions, and we will incorporate your suggestions in the process of the redesign of the website. Our licensing director is out for extended medical leave, and Mr. Matthew Cook and Ms. Phyllis Johnson are working with me as the interim director and interim assistant director to maintain an orderly and timely process in our licensing area. We received a communication sent to the governor by the Department of Defense about the licensing process for military personnel, spouses, and dependents. The only concern for this board was that the availability of the unique procedures for military personnel was not readily accessible on the website. We had made the additions and changes to the front page to let that known, but all of ours was incorporated into the licensing process. So that anybody who applies is asked the question, are you military, military spouse, or military dependent? And then we shuffle them electronically into a new way of doing their license to expedite their licensing. The DOD wanted it more readily available. Within 48 hours, we changed it, submitted to the governor, and they were happy. So we made sure that was taken care of. I attended a special meeting of the LDH licensing personnel regarding optometrists and ambulatory surgery centers for optometric surgery. And basically, there's going to be a rule change with the Department of LDH with regard to ambulatory surgery centers in general. And ambulatory surgery centers will no longer be required to have their physicians have admitting privileges at nearby hospitals. And that's where they're going with this rule change. I just want to let you know about that. We've opened preliminary discussions with a company called Envoke, which is the LA wallet operator. And we're looking at the cost and feasibility of having all of our licenses available in LA wallet, much like your vaccination card, your driver's license, and your hunting and fishing license. Apparently, Envoke is getting this from lots of other state agencies as well, so it looks like this is going to be something we can do in a cost-effective way. We've had some delays in the IMLCC process for granting letters of qualification, and these revolve around criminal background checks and fingerprinting. And so I am in the process of engaging a nationally known fingerprint expert to come work with us, spend 2 days, see what we need to do to improve and modify our existing services and machinery, and retrain our personnel for the best fingerprinting data possible. Because even though we have sent them to the state police labs, even FBI rejects them. So I've come to learn that fingerprinting is as much an art as it is a science. And we're going to see what we can do to improve our ability to get better fingerprints to not delay the processes of licensing. And at this time, I'll answer any other questions you might have.
Alan, are there any comments or questions from the public at this time? Alan, can you hear me?
Yeah, no, sir, not at this time. I was just going to double check.
Oh, good. Thank you so much. Any questions for Dr. Collada? And we'll move on to the
Yeah, the
broker
broker
report,
report shows everybody where we're going and who's signing up and where they're making the changes. I think that's reasonable for us where we are. We continue to have the occasional person who wants to change the CD broker system, but we continue to show them that it's continuing to work and we're going to be using it. And we're almost 3 years into this, and I think we've gotten it down to where it's going to work fine for everybody. So I have nothing else I think to be able to tell you.
Okay, let's go on then to the financial report.
Good morning, everyone.
Good morning.
And I'm assuming you all have the financials in your package. I'm not sure if they're going to appear on the screen or not. someone going to share it on the screen?
Do you want to share it, Ms.
You
McKinney? I can make you
Okay, that's fine. If you want to make me the host. Yeah.
okay, you're a co-host now. You should be able to share your screen.
Okay. Okay. See it okay?
Yes, ma'am.
Okay, great. Okay, good morning. I will start with the balance sheet. Oops, give me 1 second. Okay, here we go. All right, I will start with the balance sheet of the organization. The first section describes our assets, which comes mainly from our checking accounts, our accounts receivable, our prepaid insurance, and also our due from our CLAB accounts. And our total current assets are $6,938,362.37. The next section is property and equipment, less depreciation, and that's $7,151,073.26. Our other assets, which relate to our deferred outflows, that is $3,823,877.34. And that makes our total assets of $17,913,312.97. The next section is our liabilities. This first section describes our current liabilities, which are our accounts payables and our payroll, taxes, and benefits. That's $238,175.61. And the next section is our long-term liabilities. That's $18,663,177.90. And the next section is our equity. And that section totals our assets, which is $913,312.97. Next, this is our budget to actual, and this is our budget to actual for our operating account. It shows for 12 months of data. That's the actual as of December 31st, 2021. And it's $8,546,394. And that compared to our budgeted revenue. And we were on target because 1.2 million of that relates to our reserves that were used part of our budgeted revenues for last year. And the next section is our expenses. We were budgeted at 5.8 million in our salaries and benefits, and our total actually was 5.6 million. In the travel category, our actual expenditures were 1.2 million, and we budgeted 1.3. The next section, professional services, it was budgeted at 1.9 million, and we actually expended 1.2. And then our last section is our other charges. And our total for operations period was 8.1 million, and we expended 9.1. And then our next section is acquisitions and repairs and building improvements. And that section is $187,206, and we budgeted for 783. So that brings our total net income amount to $212,289.85. And that's the budget to actual for our operating account. Next is just a 3-month history for the 12 months, the income. So in 2021, we were slightly over the amount in 2020 as it related to revenues. And our expenses were 8.3 million as opposed to last year, where it was 9.3. And a lot of that dealt with the capital improvements that were made. So we were under in the expenditure column as well. The next section goes into our clinical lab. For clinical lab, our total assets, again, is mainly our cash in bank and plus the monies that we have in Braintree that we transfer over to our operating account, and our accounts receivable, that is 1.6 million. And our liabilities and equity that also equals our total assets of $1,642,712.13. And our next section would be our budget to actual for the CLAB account. What we actually brought in as of December 31st for CLAB was $401,900. And what we had budgeted was $383. Our expenses was 65, and the budgeted amount was 170. And then we have our travel and then our professional services. So our total amount expended was $186,160, and that is our budgeted amount, $350,273. And the next section, I think my third column is off, but the 3 years, 2021, 2020, and 2019 is on a different page, but we were slightly under the revenues from last year. We currently have $401,900. And that concludes the financial report. We are getting ready for our current audit, so we're gearing up for that right now. And also the mini audits, we're working on that in hopes to start by April.
Thank you so much.
Okay.
Appreciate that. Any questions?
And lastly, we also would need to do our transfer. As soon as we get the interagency agreement, the signed agreement back from the AG's office, we will transmit the $225,000 to their office. The contract begins February 18th, which was Friday. So once we get the signed agreement back, we will have to transmit those funds to the AG.
Let's make sure that check doesn't.
There's money in the bank to cover it, yes, but yes, it's 225, and that agreement ends on the 30th of 2023.
Very good. Well, thank you so much. Any questions? If not, then we'll go on to the future meeting dates, Vincent.
These are our future meeting dates. I think the most important thing to note is that if the governor, the current order is set to expire on the 16th of March, which is interesting, just about 2 weeks after Mardi Gras. And I think what the governor is probably doing is looking at, will there be a Mardi Gras related spike? It doesn't need to be extended. They really don't know. I had some extensive conversations with some of the people at LDH, and they're waiting to see what happens with the Mardi Gras. If there's a surge like they expect, they may change their mind, but at the present time, we will not have an ability to have a March meeting by Zoom if it expires on the 16th. Like if they extend it, we could have the March meeting by Zoom, but we won't know until the 16th of March to know if we can do this in person or by Zoom. And we're going to be planning to have it in person because that's the way it looks. If they extend it, we'll do it by Zoom.
And just comment on the New Orleans situation itself with the mayor there and trying to be cooperative vis-a-vis the laws of the state.
Yeah, again, the mayor has, unlike the governor has removed the mask mandate statewide, but the mayor has continued the mask mandate, continues the vaccination checks or testing checks. And so you'll know that, for example, now, if you want to go in a restaurant, the way you can get your test, if you use certain testing labs, is on the LA wallet, so that they can keep those up to date. And they're very much expanding that to keep this current in the city. And we do not know when she plans on removing that. It's possible she will consider it after the governor does what he does, but nobody knows for sure.
If she continues some of the restrictions and whatnot, will we have means of doing it by Zoom based on what the feeling is, the numbers and whatnot, and the community of New Orleans itself?
Actually, the New Orleans mayor does not have the authority to override, and Ms. Wilkin can correct me if I'm wrong. The governor's once the governor's order is no longer present, the laws for public meetings apply, would have to meet in person. And I don't think there's any way that the governor's mayor's order would override that, but Ms. Wilkin might want to comment on that, or Mary.
That is correct. Unless the governor makes some other provision, transition provisions or otherwise, if he were just simply to cease and do nothing further when the current executive emergency order expires, then ordinary law, we would revert to ordinary law and there would be no basis to have Zoom meetings. So,
Well, the bad news on the, well, of course, all kind of bad news with this pandemic, but this may be, we've tried to, Vincent's done a great job on trying to get us the information as quickly as possible about whether or not to have a meeting by Zoom, so all of the board members and the staff could make plans accordingly. And we will once again pledge to try to get you that information as quickly as possible, but with the concordance of Mardi Gras, and then I think it's the 16th.
March
Is that,
16th.
I mean, my goodness, they may not, I don't know when he'll make that call.
Well,
He
he has
may
to
make
the
it on
call.
the 15th.
Yeah, well, he has to make the call on the 15th or the 16th and
Yeah.
publish the note, because otherwise it expires on the 16th.
So it may be that late before we let you know about your plans, Zoom or otherwise.
Yes.
But we'll get it to you as soon as we have quality information. Let's see. That was the future meeting, the regulatory report.
Now we have
Mary,
the regulatory report.
yeah, I'm ready for the regulatory report now from Mary Payne.
Thanks. Before we begin that, do y'all want to do a motion and second to accept the financial report?
Yes, let's do that. Can I have a motion? Dr. Horton, can I have a second?
Weather second.
Dr. Weather seconds, all in favor? Aye.
Aye.
Opposed?
Excuse me.
Opposed? Okay, good. Then that's accepted.
Thank you.
Mary, if you would go with your regulatory report.
Sure. So, as y'all know, the rules that that we've previously approved are listed under the rules under development page. I do have a correction to that under 020102, which was the repeal of the marijuana chapter. I had incorrectly indicated that we were doing OLRC's first report. In fact, I apologize, that one has already been done and approved. And what I meant to say was that we're heading to the legislative committee with the first report to that committee. And so I just wanted to make that clarification. Otherwise, we have the last rule that was added was the January 2022 meeting of where we added the rule regarding the non-matched medical school graduates. And we have a new rule for consideration that really kind of, the issue came up during the pandemic a good bit. We found we didn't have a definition of good standing. We have something that's commonly accepted among different boards, and it seems like most people are on the same page, but there was no actual rule. And so Dr. Collada and I thought it might be nice to have that definition included in our rules. And so on page 104 of the agenda, we have a rule definition for your consideration. I can read that if that would work.
I think that's best, Mary, if you would, please.
Sure. In good standing, a license, registration, or permit that is active and not expired, suspended, revoked, surrendered, on probation, conditioned, or otherwise in a status that restricts or limits in any manner the activity of a licensee, registrant, or a permit holder under the authority of the license, registration, or permit.
Any comments or discussion on this work product from Ms. Payton and Mary and Vincent? I have one here.
Yeah, my question really is not on the in good standing, so you may want me to wait. I have questions about the licensure passing scores, some discussion about that, and about the critical need position.
Okay.
2 items above those. Shall I go ahead?
Go ahead and ask your question.
Okay, on the licensure passing scores, I'm wondering whether it would be possible to have some exception for those who have not passed the exam in a certain amount of time. My concern being that there are so many families in Louisiana who have physicians in the families, and perhaps one of their young ones didn't pass the exams in order to qualify for our license. But they may go to Mississippi or Arkansas and practice, and they may, once they mature enough, do quite well there. And then become successful in their medical practice consecutively in years. And then perhaps as they get gray, as some of us do, they may want to come back to Louisiana to practice. And we need physicians in Louisiana. Is there any, are the poor scores going to be permanent? You never ever can come and qualify for a license? Or can we add an item that if they have practiced successfully in another state without any difficulties for the past 5 years or so, they would then qualify for a Louisiana license?
I think that there's already a provision for reciprocity. If somebody's practicing in another state in good standing, that the board could consider licensing them in that respect without having to put in anything with regard to the passing scores rule. The change in the passing scores rule, you can look at it is 02.01.05. It's on page 102. And the rule has always existed exactly the way it is. And I don't think, in terms of just commenting on the number of attempts without, and the score with which you would need to pass, without having any sort of accommodation. And I don't think we've had situations where we've been unable to consider somebody who had practiced in another state in good standing, done a good job, and wanted to come back here. I don't think we've ever been limited in that regard. But y'all correct me if I'm wrong.
So Dr. Horton, you would just like some elucidation on that qualification of number of tries and score?
To clarify that, in fact, they could qualify possibly if they apply for a license after they
Either
pass.
Vincent, you or somebody from licensure.
To clarify the reciprocity.
Well, I'll clarify the reciprocity because my concern is very simply, if you want to make it 6, we can make it 6. If you want to make it 10, we can make it 10. I think the key here is that we're trying to establish, we said, write the rule. You all directed us to write the rules based upon what the standard at the FSMB was. So that's what we did. Now, this other way of getting into the license, I'll have to get more information before you bring it back. But if you don't want to follow the FSMB's guidelines, that's fine with me. Tell me what you want.
Are their guidelines, do their guidelines in any way refer to reciprocity vis-a-vis passing out of state?
This is reciprocity has nothing to do with the number of passing score attempts.
But it's a disqualification to reciprocity if you.
No, it is not.
That's her question.
That's what
That
we're
is her
wanting to
question.
clarify.
Okay,
That all
let me
those,
bring that-
clarify.
I need to bring back those details to you. I will lay it out for you clearly, and we'll do that next month, and that's what we can do, because it is my understanding, and again, I read those rules probably about 3 or 4 weeks ago. The reciprocity is unique and different to the number of times you pass the test.
right.
She just wants absolute assurance.
I'll have to do
Because
that.
she-
I want to
Because
be
there
She
honest.
hopes that's the way it is.
Because there are families saying, that's it, never ever can he come back to the farm because, he took too many times to pass his test. My second question I had was on the critical need teaching position. In that item, the 020109, I'm wondering, because I didn't see that it said the teaching position would review and co-sign the critical need positions work within any particular time frame.
Okay.
You want us to add a time frame?
Yes, and the issue is, so if this critical need position comes and has a teaching physician who's agreed to review and co-sign his work, then is that other physician going to have to be there? You know, do they do telemedicine? Do they, how does that work to get
Okay.
reviewed and
The
co-signed?
way we envision this is a little bit like a diet. Okay, clearly is not a little bit, it is a diet. They're not there to be remote monitors. They're there to be hands-on learning and evaluation and teaching, okay? And the teachers get a course in teaching, and the critical care licensee gets this training from that person. And it really is ultimately designed that they might even be adapted as partners in the future. But it's a diet, it's a diet. If you want us to take up that language, I'm happy to do that.
Well, during that time, when the teaching physician is reviewing and signing the critical need physician's work, what happens if he goes on vacation? And he's off in Hawaii for 3 weeks, then who's,
Then he would have to have a coverage around.
okay, and what's the time frame going to be like for him to review and sign that work?
We'll come back and strengthen it up for you. That's not a problem.
So bring it, we kind of got a little bit out of order here. Tell us where we are on that initiative with the medical schools.
The medical schools are comfortable with this, and that's why we're drafting the rules, and we appreciate your input.
So tell us where you envision us to be at this moment in time.
At this moment in
With
time,
this opportunity to take this to whatever it needs to go to next.
well, we'll have to redraft this, bring it back to you for approval at the March meeting, and then if you give us final approval of this, we will go on and start the process, which we will not be ready for June this year, but I think we'll be ready for the next year.
Do they have their numbers yet, Vincent, on the number of people who did not match and who have not matched the second time?
I did not ask them for any more numbers than we've already gotten, because I'm in the midst of trying to get the rules done.
Well, we need to know that because we need to know the need for it.
Well, the need was there last year, the need was there the year before. I didn't know you wanted to update the need before we proceed on with the rules. I apologize for not interpreting that correctly.
Okay, well, let me make this clear. It's not so much it's who failed the second time. Not how many don't match each year. It's how many of the ones that didn't match again.
Okay.
I mean, that's critical.
We'll
Because
answer that
if
data.
there's none of those, then there's really no need for this program. Speaking of data-driven situations, so I need that.
We
And
had
they
data
said
for the
they would
pre-
give it to us.
And we had the data for the previous 2 years. We just didn't get the March data from you. Because their matching is not up. I don't think they've done the match yet for this year.
No, I haven't. It's not March yet.
Yeah, so we got the last March's data.
Do you have the number that failed the second go-round?
In what year? This year?
Not this year.
Last
No,
year?
last year,
Yeah,
the
we
year
have that number.
before.
We looked at those numbers.
Where are they? Do you have those?
Not
So
at
you'll
my
have,
hand.
so if you don't mind, bring those back
Okay.
again, because that's critical to this initiative.
Okay, we looked at that, and that's why we made the decision, but we'll bring those numbers back to you.
I've never seen them myself. I don't know who looked at them. I don't know when it was reported to us. I don't have that memory, at least.
Okay, we'll get it back to you again. Not a problem.
How many failed to match a year after they failed to match the first time?
We have that data for 2021 and 2020, and I'll get that data for you at the next meeting. I don't have those numbers readily available.
For everybody's edification, this is quite a step forward if we do this with these rules to have folks that have not passed a match evaluation to practice medicine, give them a license for a year, for just a year. That's what has been settled upon. To see where we go from there. All of
Dr.
these
Francis?
questions that Dr. Porton asked are absolutely important.
Yes.
Any other questions?
Dr. Francis has his hand raised.
Dr.
Oh,
Francis?
it was raised. It was only to make only one data point that I know of in terms of medicinal marijuana, medical marijuana, or the recommendations for it. There has never been a recorded death of overdose from marijuana, whether it was smoked or eaten ever. But in the states that have instituted medical marijuana programs, they've shown a steady trending decrease in the amounts of death and use of opioids for chronic pain. And that's the only data point that I can think of, if that has any point of any satisfaction or comfort. That was it. I thought I took my hand down.
Oh, okay. I think you gotta watch your head going up.
Yeah, I'm gonna check it again right now. So, right.
Okay. All right, so were there any other questions other than Dr. Horton's for Dr. Collada on that? Vincent, any other comments? You'll bring back some more
I'll bring the
information?
data again. Everybody's-
And her, you're gonna look into these
Yeah, so
other
we'll-
issues.
yeah.
All right.
So Dr. Johnson, before we move on, could we have a motion to accept the regulatory report?
Yes, can I have a
moved.
motion to accept the regulatory report? Dr. Horton moves. Can I have a second, please?
Weather.
Weather seconds, all in favor, say aye. Aye.
Aye.
Any opposed?
Aye.
None opposed, it carries. Thank you.
Dr. Johnson, if I could, if there is anybody that wants to do a motion on the good standing rule, or if if there is nobody that wants to motion, then we can just move on.
Let's see, who made was there a change in the good standing rule, or did you have any?
That's a
comments
brand
on
new
that?
rule. That's a brand new draft of a definition.
Addressed it, but really.
She addressed it, I
No,
thought.
she did not address it. She said she wanted to talk about something else. We went back.
Ah.
Nobody ever made a motion on
I got
020200.
Yeah, so Mary would, ask if there is a wish for a motion on the good standing rule. Is there?
Clark will move.
Clark so moves, Dr. Horton seconds, all in favor?
Aye.
Aye. Any opposed? There being none, then Mary, that satisfies that for you.
Yes, thank you.
So we could do on that. Okay, now I see the regulatory and the combined regulatory report. Is there any difference in that?
No, sir.
Alan, are there any comments from the public to this point?
No, sir, not at this time.
All right, I'll give y'all 6 minutes. It is, let's see, it's 10:44, 10:50, we'll reconvene. And at that time, we'll be ready for executive session. 10:50.
Thank you.
What can I do?
You can hear you now.
Alan, can you hear me?
Yes, sir. You're good to go.
I'll reconvene first. Is there any comment from the public in the last 10 minutes or so?
No, sir. Not at this time.
Okay, I'll entertain a motion then to go into executive session.
So move.
Dr. Horton, can I have a second?
My
please?
second.
Sorry, Dr. Thomas seconded. All in favor, say aye. Aye.
Aye.
Any opposed? Then we're in executive session. Would you put us in the executive session room, Alan?
Yes, sir. Give me a few seconds.
Dr. O'Neill, were you supposed to be over in the executive session as well?
Yeah, they didn't send me. You can hear me, right?
I sure can. Yeah, let me try to help you out with that.
Yeah, I got left behind.
Okay, Dr. Johnson, we're back in public session.
Can you hear me, Alan?
Yes, sir.
Okay, Dr. Horton, did you make a motion to accept the minutes as revised? Can I have a second?
Weather second.
Dr. Weather, all in favor?
Aye.
Any opposed? The minutes stand. Now let's go back into executive session, Alan.
So
Dr. Horton, Dr. Weathers seconds to go back into executive session. All in favor? Aye.
Aye.
Any opposed? Alan, if you'd put us back into executive session.
Okay, here we go. Okay, Dr. Johnson, we're back in public session.
Thank you very much. Just quickly, Alan, any comments from the public so far or questions?
We did have one question about whether the executive session was viewable to the public, and I answered that accordingly, that it's not viewable to the public.
Okay, thank you. So in the matter of 5001, what are the wishes of the board on this? Do I need a motion on this, Vincent?
I'd like to make a motion to approve the waiver of qualifications for institutional practice.
So moved. You know, I have a second.
Second O'Neill.
Second O'Neill. All in favor, say aye.
Aye.
Any opposed? None. 5001 passes, Dr. Collada. On the matter of 5002, can I have the wishes of the board?
This board is going to move to approve.
I'm sorry.
I'm sorry. That was Mrs. Sport. Did you move to approve 5002?
Mhm.
She does.
She wants to grant, but, so make sure I clearly understand, the motion is to grant the license.
To grant the license.
Is that what she's approving? That's
Is that what she's recommending? Or to not grant the license?
I know it's odd, but I'm moving
Oh,
to
no,
grant.
that's what she did. She is.
Okay, I
she's
just want to make
moved
sure I'm clear.
We just want
Okay.
to make sure it's clear. Okay, is there a second to approve 5002's license? Okay,
Weather second.
Weather seconds. Okay,
Right.
So any discussion? Can't discuss a whole lot, but anyway, we'll call a question then. All in favor of 5002 being approved, say aye.
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 We better do a roll call on that. I couldn't hear all those words. Vincent, if you would.
Yes.
No matter 5002.
5002. Okay, Dr. Weather,
Yes.
Dr. Johnson,
Yeah.
Dr. Horton,
No.
Dr. Batson, Dr. Thomas,
Yes.
Ms. Sport,
Yes.
Dr. O'Neill,
Yes.
Dr. Clark,
No.
Dr. Valentine,
Yes.
Dr. Taylor,
No.
One, two, three, four, five. It passes 6-3, sir. So this person will get a license.
Okay. In the matter of 5003, the wishes of the board.
I make the move to deny the license.
There's a move to deny. Do I have a second to deny?
Sport, second.
All in favor of denial of 5003?
Aye.
Aye.
Any opposed? There being none.
Valentine.
Valentine is opposed. That passes as well to reject that. Excuse me, to deny that. In the matter of 5004, the wishes of the board.
I'd make a motion to deny the request.
I have a motion to deny. Do I have a second to deny 5004?
Sport.
Second, Clark.
Clark.
Sport seconds. All in favor of denial? Let's call the roll on that as well, Vincent.
Okay. 5004. Okay. Dr. Weather,
Yes.
Dr. Johnson,
Yes.
Dr. Horton,
Yes.
Dr. Batson, Dr. Thomas,
Yes.
Ms. Ford,
Yes.
Dr. O'Neill,
Yes.
Dr. Clark,
Yes.
Dr. Valentine,
Yes.
Dr. Taylor.
Yes.
It's unanimous.
Then I will now accept a motion to accept Ms. White's compliance council report.
So moved. Horton.
Dr. Horton, can I have a second?
O'Neill.
Dr. O'Neill seconds. All in favor?
Aye.
Aye.
Any opposed? There being none, the compliance council report is accepted, Mary. All right, we're now still in public session. Can I have a motion to go back into executive session?
So
Moved. Dr. Valentine seconds. All in favor, say aye.
Aye.
Any opposed? There being none, if you would please put us back in executive session, Alan.
Yes, sir. Give me a minute.
Hey, James, can you hear me?
I sure can.
Am I supposed to be in the other one?
Um,
I'm
if,
confused. I'm
yeah,
confused.
I can put you back over in there.
All right, thank you, sorry.
Dr. O'Neill, Alan should be pulling you in pretty soon.
Thank you. I should have texted him. James, should I just leave and then come back in?
Alan just texted me back. He said you should be able to join the executive session.
So he's gonna pull me over there?
No, I think you have to join.
Okay, here, I'll leave this and come back in. Thanks.
Okay, Dr. Johnson, we're back in public session.
All right, just quickly, Larry, nothing from the public, questions or comments?
No public comments at this time.
Thank you. All right, on the matters of 70401, which is to commence a formal investigation, and the number 70402, 03, 04, 05, and 06, which is to initiate a preliminary review. What are the wishes of the board on those? Yes, and you have us recused on the proper ones, all of us, Barry, please, on this. Barry, you know who's recused on what of these?
Sorry, I was on mute. Yes, I do have everybody. Did you want me to repeat them?
You know, with that in mind, would you feel better if we did them individually? Okay, let's take them up individually because there are a number of them that are some recusals. 70401, commence a formal review. With the wishes of the board.
Sport moves to approve.
I guess let's see, Mary, on this one, can I even be part of it if I am recused?
You're technically recused from any and all actions, any and all.
Okay, so I'll have to have let's see, Dr. Thomas still here? She had another engagement. Then I'll have Ms. Sport handle this one for me.
Okay, in the matter 70401, a request to commence formal investigation. Do I have a motion from the board?
So moved, O'Neill.
A second? I need a second.
Second, Valentine.
Thank you. Okay. Dr. Collada, would you call the roll, please?
Did we need to do roll calls on these, or we can do it by affirmation?
As long as you have the ones that the folks that are recused, Mary, if you feel confident in that, it'll be okay.
I do.
But whatever my
Okay, then.
secretary treasurer wants to do.
It's okay. Is anyone recused?
Dr.
Yes.
Johnson and Dr. Horton are both recused.
Thank you. Okay, all in favor?
Aye.
Aye.
Any opposed? Thank you. The motion passes.
The matter of 70402, initiate preliminary review. I don't believe there are any recusals on this one. So I'll accept a motion to initiate preliminary review.
So moved, Valentine.
And second, Horton. All in favor?
Aye.
Aye.
Opposed? And the matter of 70403, to initiate a preliminary review, no recusals. Therefore, I'll take a motion to initiate preliminary review.
Weather, so moved.
Weather.
Sport
A second,
seconds.
please. All in favor?
Aye.
Any opposed? Passes. In the matter of 70404, Ms. Sport, would you handle that one?
Yes, in the matter of 70404, the request is to initiate a preliminary review. Do I have a motion, please?
So moved, O'Neill.
Second, Clark.
All righty. Is anyone recused?
Yes, no to the recusals, Dr. Johnson and Dr. Horton.
I'm sorry.
Thank you.
Could you add weather to that, please?
Yes, sir.
Thank you.
Okay, all in favor?
Aye.
Any nays? No. Okay, motion passes to initiate preliminary review.
Ms.
Wait,
Sport,
I'm
would you
sorry.
please-
For 04, can you please include Valentine to that as well?
On recusal?
Yes.
question to Mary. Would that affect the quorum?
I was just about to say, do we have a quorum now?
It doesn't affect the quorum. The quorum is at the beginning of the meeting. However, it's just, do you have enough in terms of majority of the folks that did vote?
Okay.
Okay. I don't know if we have that.
Well, I was gonna say,
Well, nobody voted against it. So it's just a matter of they didn't vote, but nobody voted against it. So it passes.
okay, so we had six pass, 6 and 4 recusals.
It's not 6 because there are only 8 present.
Well, Dr. Thomas is not here. She didn't vote, is what I
Right,
hear.
that's my point, is there's only 8 present, but it passed because a majority of the folks that could vote on it voted yes.
Okay, but you're the lawyer. We appreciate it.
And Mary, I'm just making sure if we were to bring this back to like at the conclusion of an investigation and there were only 8 members that were present with 4 recusals, there would not be able to be a vote. You would have to have everyone here, correct?
Not sure I'm sorry, I'm not sure I followed your question. Say it again.
So at the conclusion of an investigation, if I was asking for a whatever, closure, whatever, and there were only 8 board members present, but there are 4 recusals, they would not be able to vote on it at that time because you would not have a quorum of the board to vote.
No, that's not correct. So you have 8 members here. That's your quorum.
Okay.
So if some recused because they're recused, it's not my understanding that it totally rejects the quorum of the meeting.
Okay.
I'm happy for Ms. Wilton to chime in if she feels differently.
Okay, just making sure.
Okay, Ms. Ford, if you would, the next one as well.
Okay, in the matter 70405, another request to initiate a preliminary review. Is anyone recused?
Yes.
Yes, it's Dr. Johnson Horton.
Okay, and may I have a motion, please, from the board to approve or deny?
O'Neill.
Sir.
Okay, do I have a second, please?
Second, Weather.
All right, all voting in favor of
Aye.
initiating preliminary reviews, please say aye.
Aye.
Is anyone opposed? No. Okay, the motion passes. Let me just keep going.
Okay, 70406 I can handle. Can I have a motion to initiate a preliminary review?
So moved, Horton.
Horton, second.
Second, Valentine.
Valentine, all in favor?
Aye.
Aye.
Any opposed? None. That passes as well. Larry, moving on to the consent orders now. We will take them one at a time. Not,
We've got the request to extend preliminary review.
hold on just a second.
Yeah, I think that is something we need to take up first.
We have did I miss one? Extended preliminary review.
Extend preliminary review for 90 days.
So Larry, excuse me just a second here on 70407 to extend a preliminary review. Do I have a motion on that?
So move, Valentine.
Second sport.
Second sport, all in favor, say aye.
Aye.
Any opposed? That passes as well. Dr. Creswell, thank you for bringing that to my attention. Then we're going on to 70501, and we'll take these one at a time as well. A voluntary surrender. What are the wishes of the board on that?
Move, we approve, Valentine.
And second, Valentine. Okay, so all in favor?
Aye.
Aye.
Any opposed? Passes. the matter of 70502, a consent order. Wishes of the board to approve or disapprove.
Motion to approve, Sport.
Second. O'Neill.
Valentine.
Second, Valentine, Sport and Valentine, all in favor?
Aye.
Say aye.
Aye.
Any opposed? Passes. In the matter of 70503, the board's wishes on a consent order.
Motion to approve, Sport.
Motion to
Second,
approve
Taylor.
the Sport, second, Weather. All in favor?
Aye.
Aye. Any opposed? Thank you. In the matter of 70504, a consent order, wishes of the board.
Motion to deny, Sport.
We have a motion to deny this consent order as it is written. Do I have a second to that?
O'Neill.
Taylor,
O'Neill votes, seconds the motion. Okay, we have a motion to deny this consent order as it is written at this point. All in favor of denial, say aye.
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 Are there any opposed to denying?
Valentine.
Valentine is opposed. Okay. In the matter of 70505, a consent order, wishes of the board. Do I have a motion?
Sport moves to approve.
Sport move. Do I have a second?
Second.
Dr. Horton seconds. All in favor?
Aye.
Say aye. Aye. Opposed? Consent order
Valentine.
passes. No, did Valentine vote no on 70505? I'm sorry, Christie, 70505.
Yes.
Did you vote against this, accepting this consent order?
Yes, I did.
Good. So that was 7-1. All right, in the matter of 7, so that passes. 70506.
Sport
Consent
moves
order
to
wishes
deny.
of the board.
Sport moves to deny.
Sport denies. Do I have a second for denial?
Taylor,
Dr. Taylor seconds the motion. I think on this one, we best take a roll call. Vincent, if you would.
Okay,
To deny is the motion.
on motion to deny. Dr. Weather,
No.
Let's see now. Dr. Weather, you're voting against the motion as it stood, right?
Yes. Yes.
okay. Dr. Johnson,
I'm going to abstain on this one for the moment. I'm thinking. Continue.
Dr. Horton,
Yes.
Dr. Batson, Dr. Thomas, Ms. Sport,
Yes.
Dr. O'Neill,
Yeah, yes.
Dr. Clark,
No.
Dr. Valentine,
Yes.
Dr. Taylor,
yes.
right now you have 5 yeas, 2 nays, and you need to vote.
What did you
Yes. Take them off.
vote? Yes.
Vote yes.
She voted yes. I'm thinking.
Oh, I'm sorry, that's yes.
I vote yes.
Okay, 1, 2, 3, 4. You have 6 yeas and 2 nays. The denial passes.
In the matter of 70507, wishes of the board on consent order.
Move to approve, Horton.
Second, Valentine.
Minute.
Oh,
Isn't that what we just did?
no, this is
No.
70507.
Okay, I just have a lot of them, I guess.
And we have a motion to accept this consent order as written. And we have a motion and a second. So all in favor,
Aye.
say aye.
Aye.
Any-
Aye.
Any opposed?
Sport opposes.
No.
Taylor.
Ford and Taylor.
Yes, ma'am.
Okay.
Yes, sir.
What about Clark? Dr. Clark voted yes.
That's correct.
Rod, you did vote yes, didn't you?
Yes, I did.
Good. Okay. In the matter of, so that passes as written. The matter of 70508.
Sport
which
moves
is
to
a form
deny.
of a motion to deny has been made. Do we have a second?
Second, Valentine.
Second, Valentine. Okay, all in favor of denying 70508, say yay.
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 Are there any nays on motion to deny 70508? Unanimous. Matter of 70509, consent order, wishes of the board.
Motion to approve, Valentine.
Second, Sport.
Second of Sport, all in favor, say aye. Aye.
Aye.
Any opposed? Unanimous. 70510.
This one has Dr. Taylor as recused.
Motion to
Okay.
approve, Sport.
Second, Horton.
Second, Horton. All in favor?
Aye.
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 Any opposed? Dr. Taylor is recused. All right. Now let's move on to letters of concern. What would
A motion, we go
closing
back
letter-
into executive session.
Second.
Yes, we do. Thank you. Yes, let's do. I'll have a motion by Valentine and a second Horton. All in favor?
Aye.
Aye.
Any opposed? None. Okay. Alan, put us back in executive session.
Yes, sir. Here we go.
We're back in main set, not
For
the,
executive session, Alan. Alan, I believe we made it into executive session's room now. Is that correct? We are not.
I don't think we are. That's not, we're live streaming.
Can you hear me, Alan?
No, you're not turned off, but he's not there. I don't know where he is.
I'm texting him now. He probably made it over.
The rest of us didn't.
The rest of us are stuck.
Even know that, and it says we're in executive session. Now we.
Hey, Alan, you back?
Hold on one second. It
There
didn't
you
get
go.
us all. So now I'm gonna go back into executive session.
All right.
Here we go. All right, Dr. Johnson, we're back in public session. James, go ahead and kill your screen. Thank you, sir.
No problem.
All right, Dr. Johnson, we're back. Y'all are muted though.
601, a letter of concern. Wishes of the board to accept.
Sport moves to accept.
Second, Horton.
Second, Horton. All in favor, say aye.
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 Those not in favor? Being none, it's accepted. 70602, another letter of concern. Can I have the wishes of the board for the motion?
Move to approve.
Move to approve.
Second.
Horton, do I have a second?
Second O'Neill.
O'Neill. All in favor?
Aye.
Aye. Any opposed? Passes. In the matters of the closed cases, 70701, 02, 03, 04, 05, 06, 07, 08, 09, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, with the exceptions of 70706. Dr. Horton, Dr. Johnson are recused. Are there any other recusals, Mary?
Yes, on 70701, Dr. Taylor is recused. On 70702, Dr. Taylor is recused. On 70703, Ms. Sport is recused. On 70712, Dr. O'Neill is recused. I believe that is it.
Okay, then I will take a motion, Mary, if this is within Robert's Rules of Order for, should I do these individually or?
No,
can I
so
do them?
why don't we do 70704, 05? In other words, why don't we just accept the ones that we have recusals on, which I can tell you which ones those are.
Okay.
That's
So-
01, 02, 03, 06, and 12.
Okay, we'll take those up then. Okay, then I have a motion to close these cases.
Wait, I thought we were going to take those out of the realm. And
Okay,
do all the rest.
70701. Can I have a motion from folks that are not, and you know who's recused?
So move Valentine.
Valentine, second.
Sport.
Sport, all in favor?
Aye.
Say aye. Aye. Any opposed? 70702.
So moved O'Neill.
O'Neill moves.
Second Sport.
Second Sport, all in favor?
Aye.
Aye.
Any opposed? It's closed. 70703. Can I have the wishes of the board on closure?
So move,
So
Clark.
moved. Okay.
Clark,
Yeah.
who's the second on that?
That was Dr. Valentine.
Dr.
Yes.
Valentine, all in favor?
Aye.
Aye. Any
Aye.
opposed? Passes. Are there any on 704, Mary, recusals?
No, but if you take 06 and 12, you'll round out the recusals and then you
That's
can
what
handle the
I'm gonna
rest.
do. 707, now can I do, Ms. Sport, would you do 06?
Yes, in the matter of 70706, do I have a motion to close?
Whether so move.
Second.
Second. Okay, all in favor?
Aye.
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 Anybody opposed?
Thank
Okay,
you.
motion passes.
70712, I believe is the other one. Is that
Yes,
correct, Mary?
That's right.
In the
Can I
matter of
have a motion to-
70712, Can I please have a motion to close?
So moved, Horton.
A second, please.
Clark, second.
All in favor?
Aye.
Anybody opposed?
Okay, thank you. Now, in the other matter, what are they, Mary? Would you let us know the others?
Sure. So the first one is 70704, 05, 07, 08, 09, 10, 11, and 13 through 36.
Thank you. Perfect. All right.
So
can I have
moved.
a motion? Clark moves.
Second.
Second. Second sport. Every-
All in favor of closure of these cases?
So
Aye.
Aye. Aye. Any opposed? Thank you.
Amen.
Now, let's see. We're going on now to the malpractice report. Dr. Creswell. No, I'm sorry. I have to go back into, I need a motion to go into executive session.
So moved.
That was Sport and Rita. All in favor, say aye. Aye.
Aye.
Aye.
Any opposed? Put us back in, you would, Alan.
Okay, here we go.
Executive session.
Here we go.
Hey, James, we're back.
There you go.
Thanks.
All right, Dr. Johnson, we're back.
Thank you, Alan. Can I have a motion to accept the malpractice report?
So moved, Horton.
Horton. Second,
Second.
Valentine. All in favor, say aye.
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 Opposed? There being none, then it is accepted. Ms. Ford, would you ask for a acceptance of the closed case report and the closed case summaries?
Okay, the matters of 8.01 and 8.01.01. Can I please have a motion to accept the closed case reports?
So moved, Clark.
Second, anybody? I need a second.
Second. Valentine.
Thank you. All in favor?
Aye.
Aye.
Is anyone opposed? Okay, that motion passes.
And Mary, Dr. Horton and I were accused on some of that.
Yes.
Okay. On termination of probation 9.01, can I have the view of the board on that?
I would make a motion to approve the termination of probation on 09/01/01.
Can I have a second?
Dr. Taylor is recused.
Support
Clark,
second.
I have a
Dr. Clark
question.
seconds. No,
Mr.
wait a minute.
Mr.
We're in
President,
open session, Doctor.
my question was, I think there was some discussion whether another, maybe an amendment would be to give him back his CDS prescribing. And I think that was something that was discussed, if I recall.
Was that your, was that the, so?
So that's just the question. I mean, we had discussed it, but we never made it. I don't know if we need to make an amendment
That's perfect.
to do it or not, sir.
So there was a discussion on more than just termination of the probation. Dr. Horton, did you wish to amend your, what is your motion, ma'am?
My motion was to reinstate his license. That was, it was for termination of probation. Right.
Okay. Well, that's fine. I just wanted to bring that up, sir, if that's what the motion is. Thank you.
Do I have a second?
Dr. Horton, do you want to include in that motion the allowing the physician to have the Schedule 2 and 3 authority back, or leave that blank?
Yes. No, he would have it all back.
You could have it all back. Okay, thank you.
That cleans it up. Dr. Clark, do you second that motion with that?
Yes, sir, I do. Yes, sir, I do.
Good. All in favor, say aye.
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 Anybody opposed? Dr. Taylor is recused. In a matter of 9.02, that, can I have a motion? What are your wishes on that one?
On 9.0201, I make a motion that we table that matter until next month's meeting.
Second. Valentine.
Dr. Clark seconds. Dr. Valentine, okay. All in favor, say aye.
Aye.
Anybody opposed? There being none, we move on to 9.0202.
Make a motion to approve the request for.
Dr. Weather has his hand raised.
Dr. Weather. Dr. Weather, do you have a motion?
I
Can't
think
hear
it was
you.
second in that.
He may have been
Dr. Weather?
second, but- Dr. Weather, he's frozen up there. I don't know if he's. Alan, is Dr. Weather still on? Did we lose him?
Yeah, I mean, he's still showing him active. I don't see any activity for his
He's
mic.
back now. Leonard, did you have a comment on 90202, did you make a motion or second a motion? I don't think you can hear.
Doesn't
I
appear
don't
he
think
can
he can
hear
hear
us.
us. Yeah.
I don't
He
think
might have to, yeah, he might have to disconnect and reconnect. Let's see what's.
Just to reinstate.
Approve the request.
To reinstate. Yeah, what is this? Okay, we have a motion. Make your motion again.
I
Dr. Hart.
made the motion to request, to approve the request from our probationer 090202.
Can I have a second?
4 seconds.
4 seconds. All in favor, say aye.
Aye.
Aye. Any opposed? Dr. Creswell, you got that down as to what on 0202?
Yes, sir.
Do we agree with you? And 90203,
I'd like to move, we approve.
we approve that as well. Can I have a second?
Clark, second.
Clark seconds. All in favor? Aye.
Aye.
Any
Aye.
opposed? So we're still in public session, is that correct?
Yes.
Are there any comments or questions from the public? Alan,
No, sir, not at this time.
Vincent, nothing's come through on any of your stuff? Nothing. Okay, good. Okay, thank y'all so much. Maybe there's just some very fascinating questions. We're very all privileged to be here and to try to make, do the right thing and to administer within our purview what we need to do for the citizens of the state of Louisiana. Doesn't make it always easy, but it certainly is interesting and we're privileged to do it. I'll accept a motion to adjourn now, if there is one, or wish.
I make a motion to adjourn and happy President's Day.
Yeah. Do I have a second?
Second, Valentine.
Ms. Valentine,
And
Dr.
sport.
Valentine. All in favor?
Aye.
Aye.
Opposed?